So which of the final appear court in the United Kingdom? Is this a higher court, Supreme Court, or Court of Appeal? Hello?
Supreme Court.
Huh?
Supreme
Samit?
Court.
Supreme Court. And what if this would have been like this European Court of Justice?
Yes, European Court of Justice.
So in that case, the option C would become, Anna. In relation to the planned economy system, which of the following system is correct? Decisions, planned economy, basically the one where the government would be taking the charge, Anna. So I think this is something we had done already. I just need to look
Yes.
forward. This was a thing that you will be having later on in the classes, but the committee stage is something not there. The fourth stage is not there, okay? This is something we can answer now. In relation to the unsettled model law on the international commercial arbitration, which party and parties should make a statement? So it should be both of the parties, right? Claimant and defendant, huh? Because just one thing, suppose there are two parties, party A and B. If both of these parties are going to the court, so they will be making their fact, right? They will be presenting what is the issue that they're facing, Hana. So this is basically the statement that they are making, Hana. So when I do say that which party should make this statement, so it will be both of the parties. Okay, even in the case of the criminal cases, when you will see that it is about the accused versus state, so state would be making their statement or accused would be making their statement. Okay, is that okay?
Yes.
If we look to the question number 12, it says that which of the following statement regarding a civil law is correct? Judges have full power of the interpretations. It is based on the code of the written law. Yes, I think this is we have done, and we were choosing on this portion because judges cannot create a precedent, and then I explained to you that the logic behind that this sometime might prove are wrong. So in that case, the best possible answer is this. If you can try on this question in relation to the unsettled model. So unsettled model is about the model law and the international commercial arbitrations. Which of the following statements correct in relation to the arbitration agreement? It must be made public. This is the main reason why we go to the arbitration, that we do not want to make things public. Okay, it must be communicated to the claimant first. No, claimant and the defendant would both coming together to the arbitrations, right? Hello, understood?
Yes.
So in that case, option A would be the correct one. So try to, for most of the time, you will see that you do not have to look for the right answer. When you're practicing, you have to also look for which one is the incorrect one. So this will further help you, because ultimately you will not have an exact question from the exam kit. What you will have something exact, like one option from a case. So, or there might be some, two option might be the same. Hana, third would be a different one, and this statement is same. So it could possible in the real example, this would be the correct best option. So you have what you have to look forward, that you have to read the question. According to that question, you have to judge which option is incorrect or which option is not true or in line. You must know the reasoning of both. If something is correct, so why it is. If something is wrong, so why it is. Okay. So what is the standard of the proof required in the criminal cases? Something you can do. In relation to the English legal system, which of the following statement is correct? The Court of Appeal is bound by the judgment of the Supreme Court. So ultimately, who will be bound by which court? So it will always be the higher court. This is always rule. Something that we will find always, that higher court will always bound the lower court. Okay. Hello. Done.
Yes, sir.
Yes, sir.
So which option would be thus, or would be here? So these are basically high court divisions, right? The higher court to the higher court will be the Court of Appeal, Hana, and the higher court to the Court of Appeal will be the Supreme Court. Okay. So which option is correct? Hello, guys.
Option A.
This is exactly the same thing that you are learning over here. First, from here you will go to the Court of Appeal, and then you go to the Supreme Court, and then you go to here. Okay, this is your sequence. Yes, A is the right answer because Court of Appeal will be bound by the judgment of the Supreme Court. Okay, and the Supreme Court will be bound by the will not be bound because ultimately you will see that Supreme Court has a higher authority, that is the European Court of Justice, but it will always be not the case that European Court will bound the Supreme Court. It could possible that Supreme Court decision might be overruled. It can be overruled by the European Court of Justice. It can possible, but Supreme Court is not bound by every decision which the European Court will be taking on. This is one of the things that you have to remember, because ultimately you cannot think because the Supreme Court of the different country would be having different set of the regulations, even though they lie under the European Court of Justice as an head faculty or head member who will be dealing with all the issues. If anything is not going to be controlled by the Supreme Court, but we cannot give the direct control to the European Court, because ultimately the cases which goes to the European Court will be like once in 1,000 cases, right? Okay, so the binding of the European Court and Supreme Court will be lower. Are you able to understand, guys, the discussion that we are having? Siddhant, would you please answer this question to me? This is for 2 marks. In relation to the English legal system, which of the following is not a division of the High Court? Hello, there?
Yes, sir.
Which one would be the answer?
Or 16?
Yes, brother.
D. Supreme Division.
Done. Now there is one more thing I would like to say. Have you seen this question? They were talking about the 3 division of the higher court, Hana? And now they are trying to know which of the division is not in court of the higher division. So can you be able to see the simultaneously in a sequence you have a 2 questions from the division of the high court? Okay. It could possible that this is something you will find in the exam kit and this is something you will find in the exam hall. This is pretty much possible. Ultimately, they will not present you something similar, but they will present you something like molding it, by molding it a bit. Okay. Able to understand what I mean to convey?
Yes.
So which of the following is not a source of the law within the civil law system? So in the civil law system, which would not be the one? So it will be the case law, right? Hana?
Option D.
हाँ. अब यहाँ पे there were some meanings to this about the Sharia law and everything. So these are all things you have to remember. Give it a try by yourself. I'm not able to remember what was the definition or what does it mean. Okay. Just give it a revision of the Sharia law and get it done. If you look to the next question, which is 19th question, in relation to the civil law, which of the following means comprehensibility? So it does mean the law is contained in the code. The codes are drafted as a specific procedure. Either the one is an option, either the 2 option, or both of this, or neither of the 2. Comprehensibility, something you will find that everything or the possibilities of the scenarios has been there, or they have been written. Now, there is one thing I would like to explain to you. For example, when I do say something is very accumulated or something which is very fulfilled. Comprehensive is means something in very detail, okay? Or something which is very fulfilled, okay? Hello, guys, are you there?
Yes, sir.
Can you be able to catch
Yes,
what I
sir.
mean to convey? So comprehensibility means something which is very fulfilled or something which is in a very detail. So could it be possible? So when I do say about something very detailed, so it will be including some of the specific procedure, right? Specific principles. It will include some of other non-specific or general principle, right? Hana?
Yes, sir.
But something is sure that these all are something written. Okay. So choosing this option would be the right option or not? When I do say compressibility, so it is the sum of the two things, the specific principle and general principles. But when you do say the course are drafted as specific principles, so this is single-handed would not be an option. But the law is contained in course. Remember I told you about codifying law? Hana? The book of civil law. You remember? The process of accumulating different section of the laws which are already made by the parliament. Able to get the discussion that we had yesterday when I was explaining about the codifying law, the consolidating law. Guys, okay, I will just take you to that page. Okay. Hello.
Yes, sir.
So sometime you will see you would be thinking that both of these two options are correct, that the codes are drafted as specific principles, but ultimately when you will see that those are contained in the codes, it would be meaning as a more appropriate one among the two which is presented, because comprehensibility will be incorporating some of the specific principles and some of the general principles which are there. Okay. And then you make the consolidating law. Sorry, the codifying law. So the law is contained in the law seems like a more appropriate one. But if you would have been selecting the wrong answer over here, so this would not be something of the surprise, because this is more of the typical question, more of the some of the confusing question. Okay. Which of the following statement is about the legislation is correct? Legislature. So there is a legislature body. So what is a legislature body? Hello.
Legislature bodies are the one who make the rules and the laws.
Okay. So which option would be the correct one out of the four? See, it could possible that legislation body would be the one who would be having two of these four options, right? But ultimately we have to select the primary one or something that is there, has a main responsibility of that body. So what is the main responsibility of that body? Didi, look at that. Whether they do implement the laws, or they apply the laws to the case laws, or whether this is a primary lawmaker in the state, whether they conduct the judicial review proceeding. What they do basically?
So option C.
Legislature is basically the body, and the parliament is basically the legislature body. Are you agree on that? And they make the legislation, the statute, and the law. So the ultimate or the supreme authority which has been given to the parliament is to make law. Okay. Either they make the law by themselves, or they sometimes delegate the legislation. Okay. So A option is the correct one over here. It's a primary lawmaker in this state. Either you would be having the law by the parliament, or either you would be having the case laws. Okay. Now the parliament can go into the delegated legislation, but that is again the part of the parliament. So some laws will be by the parliament and other law will be from the case laws. Understood? Hello. Siddhant, I think you have answered this question to me. I asked you which political system is individually freedom heavily regulated.
D.
Would you please explain this to Samvit? Why it is so? Why the freedom is heavily
In
regulated in the
demo-
dictatorship?
In democracy, people have the choice to vote in parliamentary. The representatives are elected by people. In Congress, there are like two pa in Congress is also similar to the first two. In dictatorship, there is no choice. People don't choose their leaders. People don't have individual freedoms. It is all decided by the people at the top.
Samvit, are you able to understand what has been the reason which
Yes.
has been given by done. In
Yes.
relation to the OECD, identify whether the following statement are true and false. So it is one of the body, remember? Hello.
Yes.
Organization for the Economical Cooperation Development. So basically, this is a group of the member of the countries. Basically, they aim to create something which will help in the discussing about the development and defining economical social policies. Okay. So it create legally binding agreement or it create non-binding guidelines. So what does it mean? So OECD, out of this option, we have to select whether both of these statement are the true or false, right? OECD, the one which is basically the Organization for the Economical Cooperation Development. So they will be the one who will be creating the legal binding. As you can see, the last point, they create the legal binding agreement. Okay. It creates non-binding guidelines. Guidelines are basically more on the general side, right? It has always been recommended that whatever the guideline that they are making are need to be followed by the members or at least the connected members or the connected countries who are basically the part of it, right? So guidelines more on the general side and they cannot be binding. Not even here, or probably in most of the cases, 95 cases, you will not see that guidelines. If the guidelines are there, so the possibility of getting those best binding is very less. Okay. So these are non-binding guidelines. If I talk about the next question that talks about the one of the that is a sub-body of subsidy of the United Nations. In relation to the ICC, identify whether which of the following are statement are true and false. It's settled dispute, but put before it by the statute, it is a code for the individuals. The last one, International Court of Justice. So it is a subsidy of UN. It is not a court for the individuals. It hears case between the two nations, right? So it is a court for the individual? No. It settled dispute put before it by the state. It hears the case between the two nations. It includes 15 judges. No two judges can be from the same nationality, and it settled dispute put before it by the state. By the state, they are basically referring to the country. Okay, that isn't true. So from this two of the question, were you able to identify by yourself that if you remember the key definitions or the key pointers, like this pointer, Hana, and from this question from this point, so you would be in a better position to answer these questions, right? After one we have understood, or once we have been through the explanation, the next thing is that for you to understand or to learn these areas, right? To learn these definitions, Hana, or the key pointers.
Yes.
Okay. So, wow, what is the name of the process by which the court can exercise control over the public body? So whether it would be what is the name of the process by which court can exercise control over the public bodies? It would be the judge renewals, judicial renewals. So renewal is not there, right? Hana? Renewal is something you are renewing something. It should have been the renew. So either of the C and D would be the option. So it should be the judge review or judicial review. What seems a more professional word to you? Siddhant Samvit.
Judicial.
Who is this?
Someone.
Done. In relation to the English legal system, I think Siddhant would have done this, so probably be thinking of getting bored over here. But I think you're getting a revision over. Okay. So you probably be knowing some of the extra reasoning of one or two or more options, right? So it says, yep. In relation to the English legal system, when does a parliament bill becomes an act? So it will become an act when they will be having the assent, means signed by the getting signed by the whatever the queen or king would be there, right? So when it passed through the committee on receiving the royal assent, right? Assent means something, the signature, okay? Can you be able to see that questions are based on those keywords, right? That I've been very vocal about. Hana? At least in section A. Hana? Hello?
Yes, sir.
Huh. The next question which is there that talks about what is a literal meaning. Literal rule means open your dictionary, whatever the meaning is there, ordinary meaning, we will be selecting that. So which is going to be the option over here? What should be given their ordinary meaning? The meaning of the word can be gathered from their context. From the context, if you're going from the context, in that case, you will be getting more on the side of the either on the golden or something like that, Hana? Because ultimately literal would not be the meaning over here. Words should be given their meaning, which is likely to be give effect. This is more on the purposive rule.
Yes.
Words should be given their ordinary grammatical meaning unless the meaning is manifested. So this is more on the golden rule, Hana?
Yes.
So this seems to me the one which is an ordinary meaning. If I look to the next question, which is there 28, in the context of the separation of the power, which of the following is a function of the executive? To make the law, to implement the law, or to apply the law, to interpret the law. So to interpret the law, it will be the judge rule, okay? Okay? Primarily law, it will be the one who will be making the law, and these are the legislature. So which in the context of the power, which of the following is a rule? So either it is an implementation of the law or to apply the law. 28. Executive basically they do implement, na? Apply, who will be doing? This will be again the judge role of the judge, because ultimately whenever they will be having a case, they will first look around whether this case is something that they can work on. First thing. Second thing, they will be looking into that which law is applicable on them. So once they are identifying which law will be applicable to them, is the first process to apply the law. Okay. So which are the following source of the international law? The custom treaties, judicial decisions, custom general principle law of the theories, what they're talking about.
Option C.
Option C. Treaty is basically the general agreement between the two parties. Customs, what is happening, general principle is. So these are the exact wording which they have taken, Anna. Again, something key definition which you need to learn from the Sharia law, which we have already discussed. How many members will hear the appeal made to the appellant body of the World Trade Organization? So how many were there? There were 3. Anna? Where the parties in the arbitration cannot agree on the number of the arbitration, how many will be appointed? It will again be 3. Okay. In relation to the arbitration tribunal, identify whether the following statement are true and false. It make the decisions on the 75% majority. It will state the date and the place of the arbitration. In relation to the arbitration tribunal, identify whether the following statement are true and false. It will make the decision on the majority. So what is the majority? How we can understand from here? And again, they are trying to say that it will state the date and the place of the arbitrator. So I think the document they will be making, they will be looking, or they will be at least stating kahan pe, which country they are talking about, and they will be which country they have made the decision where the arbitration proceeding has taken place and the date. So these things will be there. That seems correct to me, but I want your contribution in the very first point. It make a decision on 75%. Is this something that we have understood or have been through? ऐसा कुछ था? Hello. While we were discussing about the arbitration, was there anything like this? 75% majority? No, na?
No,
Hello.
no majority.
So in that case, we will be crossing this mark. If I talk about the next question, which is there in relation to the unsectoral model law on the international commercial arbitration, when is written communication deemed to be have received? So it was about on the day it is delivered. Okay. Remember, but there was some condition that we have to take care for the deliver. Okay. What is a primary, habitual resident, and there are certain things. If we talk about the next question, which is there in relation to the unsettled model law, which of the following characteristic must have an arbitrator have? So it's yes, please.
Question number 34 is from which topic?
Which domain?
Yes.
So there was a possibility, for example, there was a discussion when we were discussing about the arbitrator. So there was a one point which I have already discussed to you yesterday, and there we were learning about like when a communication for the arbitration process will be consumed, delivered. When we will be assuming delivered, there were some 3-4 points which you need to learn, and I have highlighted one of them. If I can just show this to you. This one. Okay. Any written communication will be considered delivered as in if it is delivered to the address personally, delivered the party place of the business, habitual resident or mailing address. If the party place of the business, habitual resident or mailing address cannot be determined, the written communication will be considered delivered if it is delivered to the address, last known persons, habitual address, and the communication is deemed received on the day it is delivered. So this was the point. This was the point on which the question was there. Okay.
Okay, sir.
Remember, I discussed this or been very vocal about this that कि वो exact wording देंगे आपको है ना on the day it has been delivered, and you will see on the day it has been delivered. Okay, they have given the exact, but because you will see that if the wording, if the place of the wordings got changed, so it might change the meaning or the interpretation of them. So mostly you will find this is one of the loophole or the weakness of the ACC paper, that most of the time you will see that the answer or the options are set it just like that way. If you just remember them, it would be easier for them. Okay, easier for you to appear or just deal with them. If we look to the next question, which is there in relation to the unsettled model law, which of the following characteristic must an arbitrator have? So there were two of the characteristics, right? The suitable nationality was not something we were not considering. We were considering independent qualified. Okay. Question number 36 that talks about in relation to the court actions, identify whether the following statement are true and false. There is a more scope for appeal compared to the arbitration. This is true. This is one of the advantage over the. This is one of the advantage that court have over the arbitration. So this is the question from the advantage and disadvantage. So remember I told you yesterday that the advantage and disadvantage would be giving you some of the questions in the practice kit. Hana? And there is a more privacy compared to the arbitration. No, this is the disadvantage of the court. This is the advantage of the court that the privacy is there more in the arbitration. So this is a false statement. Okay. Hello, guys. Please acknowledge, yaar.
Yes,
Or
sir.
even get question number 37. It says that in relation to the arbitration proceeding, identify whether the following statement are the true or false. They are look in relation to the arbitration proceeding. Identify. So we have to talk from the arbitration proceeding. They are less formal than court proceeding. True.
Both
They
are
are
true.
they tend. Hana? Done. If I talk about the question number 38, that talks about under the unsettled model law on the international commercial arbitration, which of the following will allow a party to apply the court to have an arbitration as award set aside. Under the unsettled model law on the international commercial arbitration, which of the following will not allow a party? How I would be the answer. Substantial injustice in relation to the decision of the panel, incapacity of the part of the claimant or the respondent, lack of appropriate notice to other party, lack of validity of the claim in state under which action is made. Would you please explain this to Samvit, this question, and to me as well?
This is what we learned in the appeals process, right? If like they can only appeal if there's been substantive injustice. So that is why it like
Good.
injustice will be the reason that the award
That
will be
was an
set
exact
aside.
word, Hannah.
Yes.
In the United.
Incapacity and lack of notice is not a reason because we both of those things were defined in the arbitration process.
Okay. Samvit, hello, why there?
Yes.
Would you please answer this question to me?
Which question? 39.
This 39, please. So basically, there wasn't
The burden
possibility.
of proof, option A.
Yep. Yes. Burden of proof, or it was a standard of proof?
Burden of proof.
More, it was a standard of proof. If we just go to here, to one of the chapter, so burden of proof was there. I'm sorry, the standard of proof was there. Burden does not count as in the word in the law language. So this isn't something the difference. You will see. Look, this is what they have given away, burden of the proof. But you will see the standard of proof has been a caution. Guilt must prove beyond the reasonable doubt. This would have been the standard of proof. There are certain things you need to change over here. So understood as a standard of proof, okay? If the option would have been
Okay,
this
sir.
two, so you will be selecting the standard of proof.
Okay, sir.
Okay?
Okay.
Burden of proof you can explain when you are something in writing, but you will see how I can explain this point to you. So ultimately, this is something you will be taking care of. That the standard of proof is something you will be opting. Burden of proof. Actually, you will see that both of these two options are the correct one, just to reflect the position. But the standard of proof seems like in more of the profession, but ultimately, you are saying that burden of proof. So when the claimant is claiming something from the defendant or when they are going to the court, so they will be proving their standard statement requiring what has been done wrong by the defendant to them, and the prosecution will be putting some standard proof. And I think burden of proof or burden would be on the position of the person on the accused. Burden would be on the accused and the defendant to defend themselves and accused to prove themselves they are not guilty. Okay, the person who will be providing the reasonable doubt or who will be claiming, be it the state or be it be the claimant, they have to prove their standard statement, and that will be the standard statement of the proof. And the burden would be on the position who will be saying that they are not wrong, okay, that they are not guilty, or they will be the one who will be defending. Which of the following is not in source of the English law? Was an custom law, equity law, public law, and European division directives. Not a source of the English law. The custom law was there, equity law was there, public law or
Public
European.
law.
Why? There are the two other laws, right? Public law and public law. So is this a source? I mean, like public law, how it would not be a source of the English law? Actually, it was a more of the public international law, right? Not in just in public law. Custom is basically talking about what are the custom terms. Equity is more on the side of, first it was in common law, then equity was not an additional law, but more of the improvement law that came at the place of the common law. Okay, because in the common law, the only remedy was damages. Okay, because ultimately you cannot resolve the things only with monetary damages. So equity was there, where they were more different type of resolution was there. So this was an updated version of the common law. So this was there, custom was there, equity was there. European Union directives need to be followed under, or they can be the part of the English legal. The public law doesn't seem to be at this place. If this would have been the public international law, even if the public international law, this would become the law of for the global community, right? It will not be the major source of the English law. In the English law, the major sources are common law, custom law, equity law, case law. Okay. Hello. These are 4 or 5 questions which you can attempt by yourself. I think these are 7 questions which are left. Would it be okay if you do them by yourself? Or we should done with, we can just wrap up them because we are just left less than a 2 minute now. We can try how much we can do. In the event of the respondent failing to appear at the arbitration hearing under the unsettled model on the international commercial arbitration, which of the following will be the consequences that need to be followed? The hearing will be postponed until the respondent can ensure attendance. The hearing will be cancelled and the decision will be declared in the favor of the claimant. The hearing will continue on the basis of the evidence supplied by the claimant. So remember, there was one of the possibility that we have studied, that sometime it happened that the party, if I just quickly get you through to one of the point, I think that is there. Look, if the losing party was not properly informed about the arbitration process, or they could not participate fairly. So this is one of the points that could happen. Right? This is one of the possibility where the award may be given first. It could possible that they might reject the award if there is an objection by the respondent. But if there is no objection by the respondent, in that case the award will be given and that will be fair, and that will be based on the evidence which has been presented by the claimant. Okay. So now if you just read it, in the event of the respondent failing to appear at the arbitration hearing under the unsettled model law on the international commercial arbitration, which of the following consequences will follow? The hearing will continue on the basis of the evidence supplied by the claimant, and judges will be forming the respondent. The hearing will not be postponed. They will not wait for the respondent to come. The hearing will not be cancelled. The decision will be declared in the favor. This will not be there. It cannot be that the decision will need to be in the favor of the claimant. But what will happen? The judge or the arbitrator will continue on the basis of the evidence which has been supplied by the claimant. Okay. Which of the following is not in source of the Sharia law? Faith, hadiyat, court judgment. So which one would not be the source of the Sharia law? So revise one